Good afternoon, everyone, and thanks for joining us for our Privacy and Securing Personal Information webinar. My name's Julie Shaw, and I'll be hosting today's session. I'd like to begin by acknowledging the traditional owners of the land on which we meet today. In the spirit of reconciliation, we acknowledge the traditional custodians of country throughout Australia and their connections to land, sea, and community. We pay our respects to their elders, past and present, and extend that respect to all Aboriginal and Torres Strait Islander peoples today. Now, today's webinar has been created to connect directly with you, the tax practitioner community. We value your opinion, and today we'd like to provide you with an opportunity to raise any questions that you may have directly with us. Following today's webinar, we will provide you with a copy of today's presentation slides and some helpful hyperlinks. Now, we'll send these to you via the email address that you used to register for today's session. You can also access the slides now by visiting the Webinar Resources Hub on our website, and you can locate them at tpb.gov.au/webinar-hub. I'd also like to remind you that today's webinar will count towards your continuing professional education, or CPE for short, and you can claim 1 hour for attending today's session. So let's have a look at what we'll be covering today. So in today's webinar, we'll be discussing the Privacy Act of 1988. In particular, we'll be looking into the responsibilities under the Privacy Act, what personal information is, the information life cycle, taking reasonable steps to secure personal information, tips for protecting your personal information, obligations around securing tax file numbers, and we'll also talk about the Notifiable data breaches scheme. And then to finish up, we'll share some of the questions we received during the webinar. So just make sure that if you do have any questions today, you submit them to us via the chat box. So now I'd like to introduce our speaker for today, Deborah Anderson. So thank you so much, Deborah, for joining us. I'll hand over to you now to start off the presentation.
Thank you, Julie. It's so great to be here today. Also joining me today is Terry Williams, one of our senior lawyers from our legal unit, and Craig Woodburn, our Director of IT. So they will both be on hand to respond to any of your questions that you send through throughout the webinar. And as Julie mentioned, any common questions or themes we will share at the end, so everybody has a chance to hear the questions and answers. So before we get started, I'd like to share that we, the TPB, are really proud supporters of Privacy Awareness Week. It's an annual event that highlights the importance of protecting personal information, and it aims to help organisations, agencies and the public navigate the privacy landscape. The event is run by the Office of Australian Information Commissioner, which is the OAIC, which I'll use during the webinar, and you can find more details on their website at oaic.gov.au. This year, Privacy Awareness Week runs from Monday, the 2nd of May, to Sunday, the 8th of May, and the theme is Privacy, the Foundation of Trust. For you and your business, this means that good privacy practices are key to building and maintaining the community's trust in the handling of your clients' personal information. So today I'm going to unpack the privacy fundamentals so they can help you build and sustain that trust. Our main focus at the TPB is to provide you with guidance on the reasonable steps that you are required to undertake under the Privacy Act to protect personal information that you hold from misuse, interference, loss, and from unauthorised access and modification or disclosure. This guidance is intended for anyone and everyone covered by the Privacy Act and may also be relevant to those not subject to the Privacy Act as a model for better personal information security practices. I'll also take the opportunity here to remind everyone that as a registered tax or BAS agent, you have obligations to meet under the Code of Professional Conduct, and in particular Code Item 6, which is the confidentiality code. And Code Item 6 states that unless you have a legal duty to do so, you must not disclose any information relating to a client's affairs to a third party without your client's permission. And we'll send you a link to more information on that following today's presentation. So let's start by looking at the Privacy Act 1988. Sorry, I don't know why I said 98. It was a good year, 88. So the Privacy Act 1988 is an Australian law which regulates the handling of personal information about individuals. It includes 13 Australian privacy principles, or APPs, which apply to some private sector organisations as well as most Australian and Norfolk Island government agencies. And these organisations are collectively referred to as APP entities. So an organisation is defined as an individual, including a sole trader, a body corporate, a partnership, an other unincorporated association or a trust, unless it is a small business, which in this small business definition is an annual turnover for the previous financial year of 3 million or less. So you're a small so these apply unless you are a small business operator, a registered political party, a state or territory authority, or a prescribed instrumentality, I can't say that word, of a state. I'm so sorry. I don't know why I can't say it. The Privacy Act also regulates the privacy component of the consumer credit reporting system, tax file numbers, and health and medical research. You may have a question here and say, well, we talked about it's not relevant if you're a small business with a turnover of less than $3 million, and that's a really good point. Although you are not covered by this, it is strongly recommended that you follow the principles of these privacy principles that I'm going to talk about today. The Privacy Act is administered by the Office of the Australian Information Commissioner, or the OAIC, and the OAIC is headed by the Australian Information Commissioner. The OAIC has three primary functions, and they are privacy functions conferred by the Privacy Act and other laws, oversight of the operation of the Freedom of Information Act, and government information policy functions. Their responsibilities include conducting investigations, reviewing decisions made under the Freedom of Information Act, handling complaints, monitoring agency administration, and providing advice to the public, government agencies, and businesses. Under the Privacy Act, an APP entity must protect the personal information they hold from theft, misuse, interference, loss, unauthorised access, modification, and disclosure. APP entities also need to take reasonable steps to destroy or de-identify personal information when it's no longer needed for any purpose permitted under the Privacy Act. So this could include shredding documents or storing them in a secure area. The TPB considers that as a registered practitioner, these requirements are part of your obligations under Code Item 6, which is confidentiality of client information. Now, again, many of you may not be considered an APP entity because of the carve-out of small business. I will be using APP entity and you interchangeably throughout this presentation, so just so you understand. So what is personal information? Personal information is any information or an opinion about an identified individual or an individual who is reasonably identifiable even if the information or opinion is true or not, or the information or opinion is recorded in a material format or not. Personal information can include a whole range of things. It can be a person's name, including a previous alias or name, known addresses, their date of birth or gender, their driver's license details, medical records, their bank account details, their employment details, and also things like photos and videos, and even information about what an individual likes and their opinions. It's important to consider that the personal information of one individual may also be the personal information of another individual. So, for example, a marriage certificate that contains the personal information of both parties. Personal information that has been de-identified will no longer be considered personal information. And that is if the information is no longer about an identifiable individual or an individual who is reasonably identifiable. So what constitutes personal information will vary, and it varies depending on whether an individual can be identified or reasonably identified under the individual circumstances. So as you can see, as agents, you have a lot of that information about individuals on hand. To determine if an individual is reasonably identifiable from particular information will really depend on circumstances and considerations that include things like the nature and the amount of information, the circumstances around its receipt, who will have access to that information, and other information either held by or available to the APP entity that holds the information. So if it is possible for the individual or entity that holds the information to identify the individual using available resources, or if the information is publicly released. So, for example, can a reasonable member of the public who accesses the information identify the individual from publicly released information? Let's have a look at the information life cycle now. APP entities who handle professional information will need to consider the information life cycle and how they will handle the following. Firstly, consider if it's actually necessary to collect and hold the personal information in order to carry out the functions or activities. Secondly, plan how personal information will be handled by embedded privacy protections into the design of information handling practices. 3, assess the risks associated with the collection of the personal information due to a new act or practice or change to an existing project or as part of business as usual. 4, take appropriate steps and put into place strategies to protect personal information that is held. And 5, destroy or de-identify the personal information when it's no longer needed. To effectively protect personal information through its life cycles, you need to be aware of when and how you are collecting it, and when and how you will hold it, and when and how you will dispose of it. Additionally, the life cycle may include the passing of personal information to a third party, and that could be through storage, processing, or even destruction of that information. So let's take a look at each of these steps in a little more detail. The first step about considering whether to collect personal information. Under the Australian Privacy Principles 3, an APP entity should only collect personal information that is reasonably necessary to carry out their functions or activities. An over-collection of information can obviously increase risks for the security of personal information. So therefore, the first step in managing the security of personal information is to ask whether the collection of the personal information is reasonably necessary to carry out the required functions or activities in the first place. If it is, Can the collection be minimised? And the key here is that personal information that is not collected or is not stored can't be mishandled. Next, privacy by design. Australian Privacy Principle 1 outlines the requirements for APP entities to manage personal information in an open and transparent way, which includes taking reasonable steps to embed practices, procedures and systems that will ensure compliance. The Office of Australian Information Commissioner refers to this as privacy by design. Privacy should be incorporated into every part. It should be incorporated into business planning, staff training, priorities, project objectives and design processes. APP entities should design their personal information security measures with the aim of preventing the misuse or interference or loss or modification of disclosure of personal information, to detect privacy breaches promptly, and importantly, be ready to respond to potential privacy breaches in a timely and appropriate manner. APP entities will be better placed to meet their personal information security obligations if they set them up early. And this includes choosing the appropriate technology and incorporating measures that can evolve to support changing technology over time. An important element of privacy by design is to integrate privacy into risk management strategies. Strong internal personal information handling practices, procedures and systems can assist you to respond effectively in the event a privacy breach occurs. Assessing the risks. Assessing the security risks to personal information is an important element of the privacy by design process. So you can assess your personal information risks by conducting a privacy impact assessment and an information security risk assessment, and have regular reviews of personal information security controls. You should use the privacy impact assessments and information security assessments along with the regular reviews so you are aware of the variety of security risks faced, including threats and vulnerabilities in the systems. APP entities will also, these assessments will also assist in integrating privacy into risk management strategies. And before I move on to step 4 of the information lifecycle, I'll briefly explain more about privacy impact assessments and information security risk assessments, because you probably haven't heard of these before. So firstly, the privacy impact assessment. A privacy impact assessment is a written assessment that identifies the privacy impacts of a scenario and sets out recommendations for managing, minimising or eliminating those impacts. And generally a privacy impact assessment should describe the personal information flows, analyse the possible privacy impacts on those flows, assess the impact of the privacy of the individuals, and also explain how those impacts could be eliminated or minimised. A privacy impact assessment can help to identify any personal information security risks and reasonable steps that can be taken to protect any personal information that you hold. A detailed guide to conducting a privacy impact assessment is available on the OAAC website, and we will include a link to that in the information that we send you after today's webinar. Now on to the information security risk assessment. You may also need to conduct an information risk assessment, also known as a threat risk assessment, in conjunction with the privacy impact assessment. An information security risk assessment is generally much more specific than a privacy impact assessment because it involves the identification and evaluation of security risks, including the threats and vulnerabilities and the potential impacts of these risks to information, including personal information, handled by an entity. The findings of a privacy impact assessment and information security risk assessment should inform the development of your risk management and information security policies, plans, and procedures. Once these risks have been identified, you should then review your information security controls, both virtual and physical, to determine if they are adequate in mitigating the risks you've identified. Given the processes, information, personnel, software, and infrastructure change regularly these days, and given the constantly evolving technology and security risk landscape, regular review and monitoring of personal information security controls is critical. The final point on risk management is human error. Threats to personal information can be internal or external, and they can be malicious or unintentional. Privacy breaches can arise as a result of human activity or even events such as natural disasters. Human error is regularly claimed as the cause of, I've just lost the slide. All right, here we go, sorry. Human error is regularly claimed as the cause of privacy incidents. So you can assume, or you should assume, that human error will occur and design for it. And research shows that human error can be seen as a trigger rather than the cause of an incident. Privacy impact assessments, information security assessments, and regular reviews will help you design the practices, procedures, and systems to deal with the foreseeable risk of human error and minimise its effect. The next step in the information lifecycle is taking appropriate steps. Once you have collected and hold personal information, you need to consider what appropriate security measures are required to protect that personal information. And this will need to be considered in relation to absolutely everything you do and how you do it. Key considerations when implementing these steps and strategies are things like governance, culture and training, your internal practices, procedures and systems, ICT security, access security, your third-party providers, including cloud providers, data breaches, physical security, and your destruction and de-identification processes. So let's have a look at an example and a consequence of a privacy breach. And this is a breach that's come from the OAIC website. So if you want to have a look at further examples or more detail about this example, you can go to their website. There was an investigation into a business who found boxes of, unsecured personal records being stored in a garden shed. The business advised the Privacy Commissioner that the records were transferred from a locked room inside the former premises into the garden shed at the back of the site so that renovations could be done. The garden shed door was locked with padlocks. The Commissioner found that the business did not take reasonable steps to protect the personal information, and some of that information was also deemed to be sensitive information. The Commissioner did not consider there to be any circumstances in which it thought it was reasonable to store these records or any sensitive information in a temporary structure such as a garden shed. Physical security is an important part of ensuring personal information is not inappropriately accessed, and reasonable steps that could have been taken in this situation included monitoring the movement of the physical files, regularly auditing the files to ensure there was no knowledge of the contents and that information no longer required can be securely disposed of or de-identified, implementing physical access controls such as issuing a limited number of keys or passes to areas where the information is stored, monitoring of the location in which the information is stored, and using a secure means of storage such as a safe or a secure or locked room in a monitored, guarded or staffed premises. In this case, the Commissioner recommended that the business undertake a risk assessment with respect to their records management and privacy principles. It recommended they organise privacy training for all staff and also develop a data breach response plan. The business complied with all the recommendations and also engaged a specialist privacy consultant to undertake a further risk assessment. And based on all of that, the Commissioner decided to close the investigation. And as I said earlier, further examples and more details in that example are available on the OAIC website. Destroying and de-identifying personal information. Entities must also take reasonable steps to destroy or de-identify information, personal information, that they hold once it's no longer needed. And this Australian privacy principle requirement does not apply where the personal information is contained in a Commonwealth record or where the entity is required by law or a court or tribunal order to retain the personal information. You are still required to keep business records in accordance with the record-keeping requirements of the regulatory bodies that you have dealings with, and we recommend that you check the different record-keeping requirements of the different regulatory bodies that you have dealings with, as they may vary. Destroying or permanently de-identifying personal information that is no longer needed is a really important part of your risk mitigation strategy. So next, I'll talk about the circumstances that can affect the assessment of reasonable steps. And what qualifies as reasonable steps to ensure the security of personal information depends very much on the circumstances, including the following. And that includes things like the nature of the APP entity, the size of the entity, its resources, the complexity of its operations and the business model. And they are all relevant factors to determining what steps would have been reasonable to protect the personal information held. So, for example, a franchise or a business using outsourcing is likely to provide access to its personal information to third parties, and the reasonable steps that it takes may be different to those that it would take if it did not operate in that manner. So if it was just, a small business, one premise, no outsourcing. It's important here to remember that as a practitioner, you also have obligations under Code Item 6, and you must not disclose any information relating to a client's affairs to a third party without your client's permission. And that, yes, that does include outsourcing. The amount and sensitivity of the personal information held. So the community generally expects their sensitive information will be given a higher level of protection than non-sensitive information. And this expectation is reflected in the increased privacy protections which apply to the handling of that sensitive information. Although it's not defined as sensitive information under the Australian privacy principles, people often expect that their financial information will be given a much higher level of protection. And the protections in the Privacy Act in relation to credit reporting information and tax file numbers reinforce this. The possible adverse consequences for an individual in the case of a breach is another consideration. So when an APP entity assesses the steps that they'll take to protect personal information, they should consider the possible adverse consequences for that individual concerned if the information is not secured, and that may extend to material harm from identity theft or fraud. The practical implications of implementing the security measure, including the time and the costs involved. And this will influence the reasonableness of taking that step. However, if you are an APP entity, you are not excused from not taking specific steps to protect information just because it would be inconvenient, time-consuming or costly to do so. So now I'm going to share some practical tips on how to protect the personal information that you hold in your practices. First and foremost, don't leave privacy to chance and remember your obligations under Code Item 6 of the Tax Agent Services Act. So unless there is a legal duty to do so, practitioners must not disclose any information relating to a client's affairs to a third party without the client's permission. Familiarise yourself with your internal privacy policies, processes and procedures by undertaking regular privacy training. Follow all the processes and procedures within your practice to mitigate privacy risks, including human error risks. Provide privacy notices to clients. You can include this in your letter of engagement, and understand that everyone in your business has a role to play in ensuring privacy is respected and protected. Only collect personal information that you need. And here we said, don't collect information just because it may become necessary or useful later. Now that's, I know, a really tricky one as an agent, because you don't know what you're going to need often as you're doing returns. But, don't forget, you can ask more questions later. So it's not a, once only. Access personal information on a need-to-know basis, and that includes your staff as well. Only if they need to know do you give them that information. And limit the personal information you or your staff need access to, which is kind of what I was talking about before, to protect the information from unauthorised access, use or disclosure. Make sure you keep personal information secure. So take reasonable steps to protect the personal information from unauthorised access, modification or disclosure, and also against misuse, interference and loss. Follow your policies on information security, including your IT security, physical security, and access security of your systems. Always destroy and de-identify personal information in accordance with your destruction policies. And familiarise yourself with your data breach response plan. All entities should have a data breach response plan, and I'll discuss that further in a moment. As tax and BAS practitioners, we should all be familiar with the regulation around tax file numbers, but I'll go through it quickly again, just in relation to the Privacy Act. Under the Privacy Act, the Australian Information Commissioner has a number of monitoring advice and assessment related functions regarding the handling of TFNs. And the TFN rule regulates the collection, storage, use, disclosure, security and disposal of individuals' TFN information. The rule only applies to the TFN information of individuals, and it doesn't apply to TFN information about other legal entities such as corporations, partnerships, super funds and trusts. Having said that, although it does only relate to individuals, we strongly recommend that you adhere to all of these safeguards for all entities, regardless of whether they are an individual or a non-individual. The TFN rule is legally binding, and a breach of the TFN rule is an interference with the privacy under the Privacy Act. The obligations relating to the handling of TFNs under the TFN rule are in addition to the responsibilities under other laws, which include things like the Australian Privacy Principles, the Taxation Administrations Act 1953, which includes offences for the unauthorised use, disclosure, collection or request of TFNs. Part 4A of the Income Tax Assessment Act 1936, which contains provisions relating to the handling of TFNs, and Part 25A of the Superannuation Industry Supervision Act 1993, and Part 11 of the Retirement Savings Act 1997, which provide for the collection of TFNs by the trustees of super funds and retirement savings account providers. Now, I'd like to move on to discuss the Notifiable Data Breaches Scheme. And from the 22nd of February 2018, privacy laws came into effect to regulate the reporting and notification of eligible data breaches to the Office of the Australian Information Commissioner and the impacted individuals. The Notifiable Data Breaches Scheme is an amendment to the Privacy Act and effectively mandates a reporting and notification process that the Office of the Australian Information Commissioner already recommended as a best practice. The amendment requires organisations covered by the Privacy Act to notify any individuals likely to be at risk of serious harm by a data breach, and that includes registered tax practitioners and would cover data breaches resulting from a cyber attack. In general terms, entities that are already covered by the Privacy Act must comply with this scheme, and this includes Australian Privacy Principle entities as well as TFN recipients to the extent that TFN information is involved in a data breach. This notice must include recommendations about the steps that should be taken in response to the data breach. And according to the latest Notifiable Data Breaches report from the period July to December 2021, 464 eligible notifications were received by the OAIC, and this is up 6% on the previous 6-month period. Interestingly, the top industry sectors that these to notify data breaches were health service providers, finance, legal, accounting and management services, personal services, education and insurance. The majority of those notifications reported related to cyber incidents linked to a malicious or a criminal attack. That was 55% that compromised personal information, and 41% of notifications related to human error. 4% of the notifications were a result of system faults. So complying with the Notifiable Data Breaches Scheme, the OAIC are leaving it up to entities to develop their own procedures for assessing a suspected breach. At the TPB, we recommend all practitioners ensure they have procedures and systems in place to secure their clients' personal information. You need to be prepared to conduct quick assessments of suspected data breaches to determine if they are likely to result in serious harm. And it's also important to provide training to relevant employees as to any role that they may have in responding to data breaches. The OAIC has a comprehensive guide to securing personal information to assist you in ensuring that you have the appropriate practices, processes and systems to secure personal information. And we recommend that you will regularly review and update your personal information security, as it can reduce the risk of a data breach occurring substantially. So what to do in the event of a data breach? Possibly this is the most important slide of the day. So if you have tuned out, now's the time to tune back in. If you have experienced a breach, first thing you should do is contact the ATO on 1800 467 033 so they can take measures to safeguard your client records and government revenue. Advise any of your clients that have been affected by the data breach. Contact your software provider or providers. Take steps to secure the information in your business, and contact the Office of the Australian Information Commissioner, OAIC, for assistance regarding the breach as soon as practical. And you can do that at www.oaic.gov.au. It should be noted that regardless of the implementation of the Notifiable Data Breaches Scheme, tax professionals and BAS professionals are required to notify the ATO of any unauthorised disclosure of TFNs under the confidentiality provisions of the Tax Administration Act. So before we go to questions, because I know you've probably got millions of them, I wanted to share some helpful resources with you all. And on this slide, we've got, we will send this to you at the end following the webinar. So we've got things like the Australian Privacy Principle Guidelines, the Privacy Regulatory Action Policy, which explains all the overall approach and priorities. It also, the guide to undertaking privacy impact assessments, and there's also a privacy impact assessment e-learning course which you can do, and that provides assistance on designing, conducting and acting on a privacy impact assessment. Data breach preparation and response, there's a guide to managing the data breaches in accordance with the Privacy Act. The Notifiable Data Breaches Scheme resources, de-identification of the Privacy Act, and that one provides general assistance about de-identification, so that can assist you to protect privacy when using or sharing information about personal information. And Privacy Fact Sheet 6, which is about protecting tax file number information. And as I said, we will send all of those links to you following today's webinar. Now, Julie, questions?
Yes, we have many.
How did I not get that?
Thanks, Deborah, for sharing all that information. So, yeah, let's have a look at some of the questions. First of all, you've just talked about the helpful resources and a couple of courses that people can participate in. Would people be able to claim that as CPE or continuing professional education?
Absolutely, they can.
Fantastic.
Yeah, anything to do with cybersecurity and, you know, protecting clients' data, all of that, and anything to do with the code. So, you know, this is a code 6 item, definitely CPE. So make sure you're putting it down today, guys.
Wonderful. Thank you so much for that. The next question that I have for you, you did talk about data breaches and notifying the OAIC, but could you give us some information about, you know, what sort of examples are an eligible data breach?
Of course I can. So examples of an eligible data breach include things like if data or records containing customers' personal information are lost or stolen, if a database or a software containing personal information is hacked, a cyber attack, which results in personal information being disclosed, and personal information that is mistakenly provided to the wrong person. So, you know, if you accidentally are sending, I don't know, a notification of assessment or something like that to the wrong person. So, yeah, all of that kind of stuff is considered an eligible data breach.
Excellent, thank you. Just before I ask you another question, we have had one in the chat box about a recording of today's session, so I just want to let people know that we are recording and that we will have it up on our YouTube channel very soon, so you can access it. And as we say as well, if you do watch the recording, you can also claim that as your continuing professional education, so I think that's good to know as well.
I think, and this particular webinar has a lot of new information in it, so you probably need to listen to it again to make sure you get everything.
Totally. Thanks, Deborah. So the next question I have for you is about disclosing information. So this person said in the webinar, one of the tips you spoke about was being able to disclose your client's information to a third party where there is a legal obligation to do so. So once again, can you provide some examples of when this could occur?
Yeah, really good question. Some of the circumstances where it is a legal requirement or you have a legal duty include things like information to AUSTRAC in accordance with the reporting obligations under the Anti-Money Laundering and Counter-Terrorism Act, information to a court or a tribunal. So that could be as a result of a direction or an order or, other court process to provide that information. It could be because the TPB have issued you with a Section 60-100 notice under the Tax Agent Services Act, or likewise the ATO could have issued you an order under Section 353-10 of the Tax Administrations Act. So, if you do receive those kinds of notices, you are required to give that information. But importantly, if you are worried about whether there is a legal duty to disclose information or not, always make sure you get independent legal advice if you're not sure.
Oh, that's a great tip. Thanks, Deborah. I've got a question here from Philip, and he's wondering what information should be disclosed when a client moves to another accounting firm?
Unless you have that consent from your client, you should not disclose any information. So again, without you can disclose it to the third party, being the new accountant, only if you've got the written authority from your client. So
fantastic. Yeah, so that goes back to Code Item 6, Deborah, that you spoke about, and we'll have some more information in our hyperlinks document. So if people have further questions, they can have a look at that information on our website as well.
And one of the things that can happen is that people can pretend to be a new agent. So, you just can't take everything at face value. There are a lot of very overly clever people coming up with overly clever schemes. So always make sure you check it with your client first.
Very true. Thank you. So the next question, Deborah, is it acceptable to send emails to clients that include their TFN and other personal details?
No. Email is not considered a secure form of communication. In fact, it's actually one of the most unsecure forms of communication, and I think we've seen a lot of that recently with, scams, emails being intercepted and changed, for example. So what we recommend at the TPB is that you remove any of the identifying information from the document wherever possible, and you can do that in your PDF thingy, whatever you call it. Craig can probably add to that, but yeah, definitely do not email. Use something like a portal and, or encrypted. If it is encrypted with a password, for example, through email, I do believe that, that's different, but certainly not just sending out an NOA or something like that without any security.
Great. Thanks, Deborah.
Just before I forget, sorry, there is
sure.
a note on our website called Use and Disclosure of a Client's TFN and TFN Information in Email Communication. So I don't know if we can include that in the thing, but send that out as well. That's
definitely
a really good refresher.
Thanks, Deborah. Great. So next one I've got is what should I do if I'm unsure if a person can be identified by the information that I hold?
I think if it's unclear if an individual is reasonably identifiable, always err on the side of caution and treat the information as if it were personal information. Okay. And I think, in as a tax or a BAS agent, a lot of the information that you're dealing with is sensitive information. So always, I think, yeah, err on the side of caution.
Great advice, thank you. I've got another question here. This one's about if a client sends information that's private to their practitioner via email, is it the responsibility of the tax practitioner to destroy that email?
Yes. I think so.
Simple answer, yes.
Yeah, because you've collected it and you're holding it, right? So yes, they may have sent it to you on email, which, you know, we strongly against, but you are in possession of that. So it doesn't matter how you came to be in possession of that information. It is your responsibility to store it and destruct of it appropriately.
Great, thank you. So the next question, Deborah, that I've got here is, in the webinar you mentioned cloud computing, and this person's wondering if they actually enter a cloud arrangement, what are the privacy considerations that they actually have to consider?
This is a massive one, so thank you for the question. And it's so big that we've actually got a practice note on this topic on our website, so it's probably worth having a look at that as well. And that's because as a starting point, the general factors you need to consider are how is the information being stored, whether it's being stored offshore, and what are the consequences if it is stored offshore. I believe New Zealand, for example, if it's stored on a New Zealand server, New Zealand owns it. You know, what is the processes that exist relating to the backing up or the archiving of that information? What are the security controls and the protections in place? You know, if the information is lost, does the provider have knowledge, or are they able to read your software, or is it a no knowledge provider? And what happens if there's a dispute between you and your provider, or if you decide to leave the provider, what happens to your data then? So as I said, it's a massive consideration, so thank you for that question. I do suggest you have a look at our practice note. In fact, we've got practice notes for pretty much everything on our website. Go and have a look at them. They're amazing and really practical, so have a look at that.
Fantastic. Thank you for that. I've got another question here, and this one again goes back to code item 6, Deborah, so confidentiality of client information.
Thanks for the prompt.
My pleasure. So this one is asking, is it okay for clients to provide authority to us to provide their information to a third party via email?
Yes, absolutely, as long as it's in writing, you know, and you've got a record of that permission to do so. Personally, I don't suggest, you know, SMSs to be particularly, you know, robust form of communication, but you can take it from an email. Do be really careful with the email addresses though, right? And if the question or if the request is a little weird, you might want to actually pick up the phone and ask your client and use a phone number that isn't maybe on that email, so one that you've contacted them on previously. Check that the email address is actually their email address. The scammers are really clever. Sometimes they just, you know, miss a letter or add an extra letter. So they might say, you know, Deborah, you know, with 2 A's on the end or something, and you might go, that's not that. So double check all that information. And if your gut says this is weird, double check before you do it. But otherwise, an email request is sufficient.
Fantastic. So just keeping, I guess, in the same theme of questions here, what do we do if our clients request us to send information by email to, say, a finance company, and it has all the details required in the email? Is that written authority from the client enough for the practitioner to send that personal information?
It is written. It is written authority. Again, be really careful. You know, the scammers are really smart these days. So do, as I said, if it's out of, if it just doesn't feel right, it's not normal for that client, do that. But it is, but do de-identify some of the important information, all right? So again, make sure the TFNs have been taken out. You know, consider breaking the information If it's really like a lot of information in there, consider doing it in parcels rather than as all one. At least if one email is intercepted, it might not have all the information. So I don't know, Craig might have, our IT guru might have some other suggestions in that he can put in the chat.
Excellent. Thank you so much for all that, Deborah. That was really helpful. So I think that's pretty much all the time that we have for questions today. So I'll just pop up a slide now which has got some information on how to stay in touch with us. Once again, as Deborah said today throughout the session, visit our website. There's so much information on there that you'll find useful, and you can go to tpb.gov.au to access that. You can also follow us on social media. We've got Facebook, LinkedIn, Twitter. We also have a YouTube channel, and we put all of our recordings of our webinars up there, which I mentioned before. And yes, you can still claim your CPE for viewing them. And a really good tip about our YouTube channel is actually if you do subscribe to it, you will receive a notification every time we publish a new video. So that's really good to keep track and helps with your CPE. So also we have TPB e-news, which is our monthly newsletter. And once again, you can subscribe to that on our website. Just go to tpb.gov.au/newsroom. And just to finish up, I want to say a big thank you to Deborah for providing all that useful information today, and also to our support staff in the chat box, to Craig and to Terry. Thank you so much, and thank you to everyone in the audience for joining us today. If you are interested in coming along to another webinar, just again jump on our website and go to tpb.gov/webinars, and you can register for one of our upcoming sessions there. And then lastly, just to finish up today, I will be launching an exit survey, and we would really appreciate it if you could take the time to complete it. It's very quick, really only takes a moment for you to complete, but it is really useful for us to hear your feedback. It lets us know of topics that are of interest to you so that we can keep presenting our webinars and giving you information that you need. So yeah, the survey will just pop up in your browser when you leave today. So once again, I just want to say thank you. Thank you for joining us today. We do hope that you stay safe and enjoy the rest of your day. Thanks, everyone.
Thank you, everyone. Bye.